In Pretoria has ruled that accused 3 in the Senzo Meyiwa murder trial, that's Melusi Xulu, should not be kept in solitary confinement. Now, since 2020, he's been confined to his cell for up to 22 hours a day. Accused number 5, Fisokuhle Ntuli's bid to also be moved from a single cell was, however, struck off the roll. Let's get you some analysis now. Melusi Xulu is a legal analyst and he joins us via our video link. Melusi, it's always a pleasure talking to you. And let me thank you for your patience in waiting for this interview. Let's talk about the conditions that Xulu says he's been held in for the past 4 years. What are the regulations around holding someone incarcerated for this length of time in solitary confinement?
Good afternoon to you, Michelle, and to the viewers at home. Well, the solitary confinement at CIMEX prison, it's in terms of the SOPs, is that you must stay there at a minimum of 12 months to 18 months. And then if there is a risk, you'll stay beyond that. So in terms of Mr. Xulu's situation is that he's been there since 2020, as you say. So it's beyond the minimum time that he could stay in solitary confinement, because they are saying if you are perceived to be a dangerous convicted person, maybe just before you are taken to stay with other prisoners, you must stay there for a period of 18 months. So his complaint is that he's staying there for 22 hours without human contact. He doesn't have any reading material, doesn't have a radio or a TV, and he can only phone his family for a very minimum of time per month. So it's a very difficult situation for him to be in for 4 years.
Yeah, absolutely. Let's take a look at what the Constitution says, Melusi. Section 35 says every prisoner has the right to conditions of detention that are consistent with human dignity, including exercise, provision at state expense of adequate accommodation, nutrition, reading material, and medical treatment. It also goes as far as to say the United Nations Office, on drugs and crime, says that keeping someone in conditions of solitary confinement, and this is 22 hours a day in solitary confinement, is considered torture. He's been in solitary confinement, as we said, for almost 4 years.
Yes, it does show that, his constitutional rights have been violated. If you look at Section 33, subsection 1 of the very same Constitution, it says every administrative action must be just, it must be fair, it must be reasonable. And in his case, you can see that it was not fair at all. I'm even challenging the aspect of 12 months to 18 months, in my view, because, the purpose of solitary confinement, Michelle, amongst many things, is to have a corrective measure of a person who must not behaving himself, possibly, and is to, keep a dangerous person at the prison away from other prisoners, but for a certain amount of period. So once you come in for the first time, and people or at the prison will say they will take you to solitary confinement for 12 months without anything that you've done wrong beyond being convicted, I think it does have some, issue that must be taken up to a constitutional court, I believe. I think there's a gray area beyond these 12 months that they are saying, because you can't say you want human rights to be supported, but you are not practicing it. This is why, if you read the judgment in the introduction, it says even if a person is the most hated person, they still deserve, to have their constitutional rights being respected. And I think that is what we saw today.
Yeah, it's about the Constitution and about the Bill of Rights, no matter who you are, right? And Xulu describes his assistance, his plea for assistance to the court, as a plea for assistance not about discomfort or mere inconvenience. He says he suffers from insomnia, fatigue, feelings of hopelessness. He says he sleeps on a sponge mattress that rests on a concrete table. He eats alone in his cell. He's allowed 10 minutes of telephonic contact with his family 2 times a month. The lighting in his cell is very bright and causes him migraines and feelings of disorientation and of anxiety. I mean, I just wonder, his application was obviously granted in the High Court today, but the fact that Fisokuhle Ntuli's application was denied on the basis of a lack of urgency, it means that he will continue to live under these conditions for a long time to come still.
Yes, in particular to Senzo Meyiwa, I was very interested in that. But what he still has a right to is can still apply on a normal court roll because it was not on an urgent basis. But I still believe that, solitary confinement without any evidence that shows that you might be dangerous or maybe you've been ill-disciplined, I think is still inhumane. So I think he can still apply on a normal court roll and see how he can take it, because solitary confinement should have a reason. It shouldn't just be because we perceive you to be dangerous when there's no reason. But as I said, it will depend on the circumstances. Maybe there are other reasons that needs Senzo Meyiwa to be in solitary confinement besides what we know.
Yeah, there's the Jail Commission the Jali Commission, in 2005 found that solitary confinement is a product of our past and should not be resorted to as a norm by prison officials in the new democratic order. It's now more than 20 years or almost 20 years since that commission, and yet we continue to treat prisoners in this way. Perhaps also interesting, Melusi, to just sum up part of the commission's findings. The commission saying that prisoners being kept in these conditions are for the most part extremely dangerous. The state has to keep them in prison to protect everyone else's rights, but prisoners' rights should not be restricted more than necessary. We degrade our society if we allow the state to torture people. Perhaps something for all of us to think about as we wrap up that conversation. Melusi Xulu is a legal analyst. Thanks very much indeed for joining us this afternoon.